as well, the likelihood of this being reviewed again by Tanya Chutkan, the Fisher story not going away, all of a sudden becoming, as we have said repeatedly on this broadcast for many months, one of the most significant cases pending before the Supreme Court in the entire Donald Trump regimen, if you will. We know there are 3 cases altogether. The Colorado case, the Supreme Court finding a number of weeks ago, of course, that Donald Trump can remain on the ballot there. The second case, this immunity case, coming up for oral argument also this coming week on the 25th. We'll get back to that when we give you a calendar for rule of law events. And then, of course, this Fisher case. We're going to chat about all of that, give you some snapshots as well about a couple of cases. The Supreme Court decided just this past week in the area of veterans benefits and employment rights, a 7-2 decision, a 9-0 decision, unanimity on the Supreme Court. Who would have thought? 9-0 in a case called Muldrow versus City of St. Louis. I'm going to give you just a snapshot of what that's all about. And then necessarily we're going to talk about other things related to the administration of justice in America, including white-collar offenses. Spending a lot of time talking about deterrence, the importance of specific deterrence, as we have chatted before on this broadcast, stopping an individual from engaging in behavior, and also general deterrence, messaging to the entire community about what is and is not acceptable in the ambit of behavior out there, specific and general deterrence, purposes of criminal prosecution, and how is that going to be invoked and invested during the course of our weekend broadcast now? The answer is we're going to look at a couple of cases, both of them now resolved in the white-collar area, huge amounts of fraud both in New York, the Sam Bankman-Fried matter, and another case, yes, that's right, overseas in Vietnam. A stunning verdict entered with respect to a fraud defendant in that case. We're going to talk about the significance of that, and then more generally, in the area, once again, of case notes, what is the impact? What is the deterrent impact upon our community generally, the general impact, general deterrence, when it comes to the imposition of these huge sentences? And in the second case in Vietnam, the most dramatic thing that a government can in fact do when it comes to imposing a sentence in the wake of a criminal conviction. We're going to talk about all of that, white-collar offenses, and the deterrent impact that those have, not only upon the individuals, that's specific deterrence, and then also general deterrence upon our community generally. We're going to go back then and, of course, do some updating on all of this. We've got a big week coming up. We'll give you some calendar entries for you to place on your kitchen calendar so that you can watch what's going on Monday and Tuesday and Wednesday and Thursday and take part in the rule of law. It is upfront. We've got an upfront seat for all of us this coming week, as we always do here on our weekend broadcast. And finally, we're going to be observing here, as we often do, some milestones in history. The specific milestone this coming week is a major birthday, a 460th birthday of an individual who has changed the way that we talk, changed the way that we think, changed the way that we engage with each other. We're going to chat about that particular 460th anniversary, and yes, the interface between that person, and yes, of course, the rule of law and judges and lawyers and government generally, all of that coming up on our weekend broadcast here on Amicus, a law review. A lot to take in. It is a lot, but we're going to spend some time getting you into the depths on all of this. And again, as always, taking your phone calls at 844-967-2789, 844-967-2789.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law. WAUK.
Save big money on your entire roofing project now at Menards. Protect your home for years to come with Owens Corning Architectural Shingles. They offer long-lasting performance while providing ultimate protection with a 130 miles per hour wind rating and limited lifetime warranty. Choose from over 50 options of Owens Corning shingles in-store and on Menards.com. And check out more of our great deals going on now.
Save big money at Menards.
Hi,
Hi, I'm Jenny, manager of a brand new store in town called Big Deals. It's not a brick and mortar store, but rather an online marketplace. What makes this place so great is it's filled with gift certificates to local businesses in town. Shop local, buy local, and save money. That's our motto. Big Deals. It's kind of a big deal.
You're listening to The Shaw, WAUK, Waukesha's home for the Tom Albaugh Show.
This is Amicus, a law review. My name is Jim Santelle, your host for this hour and next hour. This, our weekend review of law and government and the aspiration for justice. Some aspiration for justice going on this week, next week, and the weeks to follow in a criminal state courtroom in Manhattan. You know what this case is all about. We have talked a lot about it. It is all over the news, of course. This is the first time in our nation's history in which a former president has been brought into a court of law in a criminal setting. Other presidents sued civilly, but this is the first time a president is brought into a criminal court and called to answer for criminal charges, in this case brought against him by the state of New York and by the DA's office, in particular, the DA there, Alvin Bragg, alleging that Donald Trump engaged in a violation of state law when it came to the administration, the maintenance, the development, and the generation of documents, financial documents, attempts to hide the fact that he was paying off a porn star named Stormy Daniels to keep her quiet in advance of the 2016 election. Now that's the superficial part of the case. And as you know, the judge in this matter, as we talked last broadcast, described for the jury what this case is really about. And Alvin Bragg, almost certainly in the course of opening statements on Monday, will repeat this fundamental notion that, yes, at some level, this case is about sex, and it is about an affair and those kinds of salacious things that perhaps the tabloids, including the National Enquirer, which, believe it or not, is a part of this case too, that they may revel in. But it's more than that, and it's more than even a violation of New York state law when it comes to misrepresenting what the documents are about here, misrepresenting the purpose behind invoices and checks and ledgers. That's how you get up to 34 counts altogether, 11, and 12 or so. All of those kinds of things go into this indictment, charging these violations of New York law based upon the documents. But beyond those first two predicates, that is the sex part of this, that is the documents part of this, the larger issue, as Juan Merchan, the judge, instructed the jury at the start of this selection process, this is an issue, this is a matter involving election interference. Why? Because the motivation for doing this, the motivation for paying off Stormy Daniels is not simply to quiet her, but rather to deceive, if you will, to try to undermine the information out there with respect to this candidate who at that time was running for the presidency. And that's going to be Alvin Bragg's principal focus on Monday, I suspect, when he is before a jury, explaining to them in opening statements what this case is all about. We'll get back to that in just a moment or so. But let's talk for a minute about the jury itself. Again, last broadcast, we spent a lot of time talking about these 42 questions that Judge Merchan has been asking, quite literally, hundreds of prospective jurors from Manhattan, all residents of the area, coming in to be questioned about whether or not they can be fair, they can bring to this deliberative process their perspectives, yes, but their capacity, their intellectual capacity, their critical thinking, so that they, in fact, can decide a case, these charges, based only upon the evidence in the four corners of that courtroom. And although it might seem difficult to do, I believe, as I have said before, I'll reaffirm today, and I think the selection process proved this past week, jurors can, in fact, set aside their views. Many of them spoke eloquently, and perhaps not so eloquently, about the capacity that they have to do this kind of thing. even though they may have biases, they may have opinions about the defendant, may have opinions as the judge asks them about the legitimacy of a prosecution of a former president. All those kinds of things went into the mix. All those things are part of the questions. And in the end, something significant happened at 4:35 on Thursday afternoon of this past week, when Judge Juan Merchan said, we have our jury. Well, he was a little bit premature, principally because yesterday he selected 6 more alternates, and they were added on to the 12. And so we actually now have a panel of 18 altogether who for the next, 5, 6, maybe 7 weeks or so are going to be listening to the evidence presented during the course of this trial. And why does Judge Juan Merchan add 6 more to that basic panel of 12? Well, the answer is this is going to be a longer trial. Certainly not the longest trial ever tried in Manhattan in American history, but nonetheless, a significant span of time. And during that time, it is likely, we don't predict it necessarily, but it's likely that at some point someone may become ill for a day. Someone may have a family commitment, some business commitment that's going to take them away, even for an hour, even certainly for a day. And if that happens, that person needs to be excused from the jury, because every single juror has to listen to every single minute of the trial presentation. And absent that, you do not have a proper verdict at the end. And so if we do lose panelists among the jury of 12 already brought together, again, the judge saying we have our jury on Thursday afternoon, if any one of them drops away, then the alternates take that spot, and we do not have a situation where we have to go back and reselect a new jury. If you drop below 12 people, you then have a mistrial. You don't have a dismissal of the case, but you've got a mistrial, and that means you do have to start over. The judge has added 6 more people, assuming that during the course of the next 6, 7, maybe 8 weeks or so, you're not going to get more than 6 people who are going to come forward and say, I can no longer serve. So let's begin to talk. Let's begin to talk about exactly who is on this jury, this selection process that ended up with 12 people. Let's talk about them. Juror number 1, he's going to be the foreman. Works in sales, lives in West Harlem, says he enjoys outdoor activities. He said he gets his news from the New York Times, watches Fox News and MSNBC. He said he heard about some of the former president's other criminal cases, but did not have an opinion on them. Interesting. All that comes out again of the so-called voir dire process. Juror number 2 works in finance, lives in Hell's Kitchen, again in Manhattan. He said he likes hiking and music and concerts and enjoying New York City generally. He said he follows Donald Trump's former fixer, Michael Cohen, who, of course, is going to be a witness in this case, expected to be a key witness, if not the principal witness for the prosecution, follows him on social media. Interesting, right? But he also said he follows figures like former Trump advisor Kellyanne Conway. And so this is a person who is out there watching what former members of the Trump administration are doing. He said he believed Mr. Trump has done some good for the country, adding it goes both ways. Juror number 3 works in the legal field, lives in Chelsea, said he does not follow the news closely, but when he does, he reads the New York Times, Wall Street Journal. Apparently, we've got a lot of New York Times readers here, finds articles using Google. He added that he was not very familiar with Donald Trump's other cases out there, plainly because he doesn't listen to this weekend broadcast. Juror number 4 is an engineer from the Upper West Side, asked how he was doing during the jury selection itself. One of the participants asked this juror number 4, how are you doing? And he responded, I am freezing. That's plainly a reference to the temperature in the courtroom on that day. When a lawyer asked if he had strong feelings about Donald Trump, he responded, no, not really. Juror number 5 works in education. He is from Harlem. He said he tries to avoid political conversations, doesn't care much for news. She said that she appreciates Mr. Trump's candor. President Trump speaks his mind, she said. I would rather, she said, that in a person than in a person than someone who's in office and you don't want to know what they're doing behind the scenes. All of this to indicate, of course, that you have got jurors who do have opinions and do have perspectives, and they do bring into this process some things in their mind, but all of them passing the bar, if you will, and making the determination, that as the judge did, that these people can, in fact, set aside those biases, those past involvements, and make a decision based upon what they find and hear and take in during the course of this trial now coming up. When we return here, we're going to talk more about the remaining jurors on this panel of 12 right here on Amicus, a law review.
To Amicus, a law review with Jim Santelle. Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law.
CBS News Brief. Opening arguments in the hush money trial of former President Trump begin Monday. Meanwhile, a man who set himself on fire outside the Manhattan courthouse has died. Fred Gates saw the whole thing.
Before he doused himself, he threw a bunch of flyers into the air. He went into the backpack and flew them all with a flourish, like way up.
The man has been identified as Max Azzarello of St. Augustine, Florida. House Speaker Mike Johnson's job may be on the line. Here's CBS's Scott McFarland.
A third hardline Republican, Arizona's Paul Gosar, has signed on to a plan that could oust his fellow Republican Mike Johnson as U.S. House Speaker. The group has criticized Johnson for pushing a major proposal largely supported by Democrats.
That major proposal includes foreign aid to Ukraine. Employees at a Volkswagen plant in Chattanooga have voted to join the United Auto Workers Union. This man was among them.
The people that do the job, build the cars, our voices need to be heard. We need to be treated fairly.
CBS News Brief. I'm Linda Kenyon.
Obviously. So maybe I'll start a little more soon. But great. That's fine. Great. No problem. Good.
A Brewers win in St. Louis. Hi, I'm Mike Clemens. The Brewers in a weekend series against the Cardinals. Milwaukee with a 2-1 win last night thanks to the game-winning RBI in the 10th by William Contreras. NBA, the Bucks held practice, getting ready for Sunday night's Game 1 against the Pacers in Milwaukee. Damian Lillard, dealing with some injuries, asked when will he return to practice?
I went today. Today was my first day doing live stuff. I was battling a few nagging things leading up to that last week, and we got the 2 wins that we really needed to get. And then going on that last road trip, I knew I wasn't going to play the OKC game. Then the Orlando game was like, we don't know how everything else is going to go, so, let's give it a go. And then halfway through that game, we see Cleveland lost. Second quarter of that game, I kind of aggravated my Achilles. So after that, it was just like, we got a week to get right, to get ready, and that was kind of the focus.
That's the Bucks' Damian Lillard. With sports, I'm Mike Clemens.
With your forecast, I'm Corey Hartman. For today, mostly sunny, highs near 48, frosty tonight, low 30s. For Sunday, sunshine and highs in the upper 50s. Clear skies, a low of 37 for Sunday night. On Monday, some sun and clouds and a high near 62. Rain showers likely Monday night into Tuesday.
Currently 33 degrees.
Most of us agree that every Wisconsinite deserves affordable health care. California mega millionaire Eric Hovde does not. Hovde said he would repeal the Affordable Care Act, quote, in its entirety. What? The Affordable Care Act protects people from insurance companies refusing coverage for pre-existing conditions and stops them from dropping your coverage if you get sick. If Eric Hovde got his way, millions of Americans could get hit with increases in their healthcare premiums of 20% or more. Millions more could lose coverage altogether. Hovde even spoke out against parents helping their kids by keeping them on their health insurance plans until they turn 26. Now that might be okay for Eric Hovde. His businesses have raked in millions of dollars in handouts. But it doesn't cut it for hardworking Wisconsinites and our families. Call Eric Hovde at his California office, 714-730-4444. Tell him we support lower health care costs. Paid for by Better Wisconsin Together Incorporated.
Hey Wisconsin, it's construction season and the Wisconsin DOT wants to help you safely navigate work zones in your area. Check 511wi.gov or download the free 511 app to see current road work, closures, detours, and camera views on your route. Wherever your travels take you, know before you go with 511wi.gov. That's 511wi.gov. And remember, know before you go. Always park the phone while driving. Sponsored by the Wisconsin DOT.
The Todd Alba Show.
Luke, I'm just going to say it again. The real problem here was that goofy in-season soccer tournament that they had. That threw everything off.
What are you talking about? That was December basketball. You just couldn't figure out the rules.
You're exactly right. There are goofy rules I couldn't figure out. I don't like them.
You would not do well with driving on the left-hand side of the road.
Oh,
if
absolutely
you were
not.
to go.
Absolutely
you would
not.
just start freaking out.
Yeah. The Todd Alba Show. Weekdays noon till 2 on your local Civic Media radio station and on the app. Todd Alba,
Join us next time live from Governor Nelson State Park as we talk to Tia Nelson, the daughter of the late, great governor of Wisconsin who created Earth Day, right here.
The Todd Albaugh Show, weekdays noon till 2.
This is Amicus, a law review, and my name is Jim Santelle. I'm your host this hour, next hour, as always, with my wonderful producer, Johnny, here in the studios of WAUK Radio in Waukesha, taking your phone calls, your inquiries, your questions from around our civic media broadcast neighborhoods throughout the state of Wisconsin and beyond. That number is 844-967-2789. Appreciate already Sherry from Horicon letting us know that she's enjoying our show this morning. Lots to consume, Sherry, lots to digest here this morning as we continue our discussion about the selection of a jury, the first time in our nation's history that a jury has been impaneled, 18 people altogether, a core jury of 12 and 6 alternates in case some should drop away during the course of the trial for various reasons. All of them now impaneled, going to be hearing evidence beginning on Monday with opening statements from the witnesses, from the parties rather, and they're going to be talking about the witnesses during the course of those opening statements. But let's chat more about who these jurors are. Again, significantly, the judge, Juan Merchan, was very concerned, as you know well, about the identities of these jurors. And he made it clear from the start in his order that we talked about last week that he's not releasing to anyone in the public their names, certainly their addresses, and other identifying information. He seemed particularly annoyed this past week by some reporters' firsthand observations. He asked them to refrain from writing about anything that you observe with your eyes and hear with your ears related to the juror that's not on the record. Not on the record. In other words, all the things we're talking about this weekend on our broadcast, these things on the record, part of the public record, but not discussing anything related that would give more indication of who these people are. And so that issue becomes very significant going forward for the safety, the security of the jurors, and the integrity of the process generally. We will get back to that in just a few moments or so. We're talking this weekend about who these jurors are. What do we know from the record that Judge Juan Merchan has permitted to go forward? Juror number six works in technology, lives in Chelsea. She said she gets her news again from the New York Times, Google, Facebook, and TikTok. She said she probably has different beliefs than Donald Trump, but she said this is a free country. Good for her, right? Juror 7 works in the legal field, lives on the Upper East Side there in Manhattan. He said he's aware of Donald Trump's other cases, but does not have an opinion about Donald Trump's character. He said he has political views as to the Trump presidency, agreeing with some Trump administration policies and disagreeing with others. Juror number 8 from the Upper East Side there in Manhattan works in finance. He said he reads the New York Times again, the Wall Street Journal, watches CNBC and the BBC. Said he enjoys fly fishing, skiing, and yoga during jury selection. He said he had no questions, no beliefs, no opinions that would prevent him from being impartial in the case. Of course, that a question asked of every single juror and having to convince the judge, of course, of the legitimacy of those statements, right? Juror number 10 is a businessman who lives in Murray Hill. He said he does not follow news as, if anything, it's the New York Times, but he said he likes listening to podcasts on behavioral psychology, adding it's my little hobby. He said he does not have a strong opinion on Donald Trump. Juror number 9, who I skipped over here, works in education, Upper West Side, and said of Donald Trump, he was our president. Everyone knows who he is. Adding that when he was in office, everyone was kind of talking about politics. Juror number 11 is a product manager, lives in Upper Manhattan. She said she does not have strong opinions about Donald Trump, but added, I don't like his persona, how he presents himself in public. But then she added, I don't like some of my coworkers, but I don't try to sabotage their work. Drawing laughter, of course, from the other members of the jury pool there, and from the group assembled there in Judge Merchan's courtroom generally. Juror number 12 works in healthcare, lives on the Upper East Side. She said she likes listening to live music and hiking, also listens to religious podcasts. Now, why have I chosen to give you some sense of who these folks are? Once again, it underscores this notion that we are not looking in a jury for people who have no perspectives on the world, maybe even have some perspectives in this case about a very well-known defendant. He is a former president, as at least one of those jurors plainly appropriately said out loud. The question, once again, is can you set aside whatever you have read in those publications, on those online social platforms that you visit from time to time? Can you set aside those things intellectually? Can you engage in the critical thinking that permits you to listen to, beginning on Monday, the opening statements from the trial attorneys? Listen to those. By the way, those opening statements, not evidence in and of themselves, and Judge Merchan is going to instruct the jury on just that point. But listen then to the witnesses and assess their credibility, determine whether or not they are believable. And in the end, the question to be asked at the end of this 6, maybe 7-week trial altogether is, has the government proven its case in this courtroom, not out there in the media, not out there on the streets of Manhattan, other places around the nation? Has the government in this trial proven its case beyond a reasonable doubt? And can a jury unanimously render and reach a verdict they can all agree on? A unanimous verdict has to be that in the criminal setting. That's the issue. And the diversity, if you will, of the perspectives, people who have differing views on Donald Trump, did not prevent them from being on the trial jury. And for that reason, it is an endorsement of what we do in America, and affirming once again that we do have people, not everyone. We plainly know from the coverage that there were some people, many people early on, who raised their hand and said, I cannot be fair and impartial for whatever reason that may have been. And they were summarily dismissed. They're no longer part of this process. All these people acknowledge up front, they admit to what their background has been. Not that there's anything at all embarrassing about that or illegal or improper. They acknowledge who they are, but nonetheless have convinced the judge and convinced the trial attorneys as well that they can do their job appropriately. And in that connection, another case note or two just about this, the importance of jurors, prospective jurors coming forward and being honest about all this. We know that there were at least a couple of hiccups early on Tuesday and then into Thursday again, as a couple of jurors came forward and were removed from the panel. One potential juror who initially said she could be fair, was confronted by the defense team over some social media posts that she had made in the past, including one in which she called Trump a racist and a sexist. And reading it out loud, she then stopped and she said, oops, that sounds bad. And she was excused. And the point of that is that she was not being candid with the members of the judiciary there, obviously the judge himself, but also the entire rule of law apparatus there. And in those circumstances, it may well be appropriate, and it was appropriate, to dismiss her from the case. We also know there was a second juror. We don't know a lot of the information about this, but the DA's office came forward and said overnight, we've discovered something else about another juror who also came forward, and basically some information about that juror that was not previously known, indicating that juror had also misrepresented something about himself or herself, and therefore the number 7 was reduced down to 5 going into Thursday. There was a second juror, again, already paneled, who came back and said, you know what, I have been identified basically by some family members who saw my description. They have confronted me about this, and I have determined that I cannot be fair. Good for her to come forward in the course of this process. Good for her to say that before she is seated on the panel, and the judge dismissed her as well. And so that's how you went from 7 to 5, and then reached 12, and then 18 at the end of the week just yesterday. So all of that underscoring the importance of this process and the importance of jurors being honest, telling you who they are, what their background has been, not necessarily identifying them with such great particularity that they can, in fact, be identified by the media. The judge, again, plainly sending a message to the media, telling them that he is going to do whatever he possibly can do to prevent their identities from being known. He said this, he said, if you can't do that, if we can't stick to that, we will have to see what else we need to do to ensure that the jurors remain safe. That was Judge Juan Merchan near the end of this process. The focus on truth, the focus on safety, the focus on security, all of those things as a part of the perspective on what has just happened. Now, there's one other aspect of this that we need to address during the course of our weekend broadcast, and that is this continuing issue related to the order that Judge Juan Merchan entered and then amended to prescribe for, yes, this defendant, but for every other defendant in a state or federal court, that you do not do things both in the courtroom and outside of the courtroom that could have an influence upon the jury, upon the course of deliberation, upon the presentation of evidence generally. And we know that order that the judge entered basically told the defendant that he was not to make any comments, whether they're oral or written, about two broad categories of people, the witnesses and also the jurors, and also then added on court staff and their families as well. But the witnesses and the jurors, that's the key to all of this. Interestingly, Juan Merchan excluded himself from that. He said, you can go ahead and criticize me. And he also excluded the DA's office and Alvin Bragg. You can criticize the prosecutor too, but you cannot say things about the integrity, the legitimacy, the credibility of the witnesses, or talk about the jurors in a way that's going to compromise this trial. And so what has happened now, late in the week, is that the prosecution, the DA's office, has filed a motion and asked the judge now to enforce that order. Why? Because the prosecution has identified not just one, not just two, but seven different times in which Donald Trump has violated that order to ensure the integrity of this process. Among other things, they've identified early on something that we chatted about here on our weekend broadcast. He referred to Michael Cohen and Stormy Daniels as two sleazebags who have with their lies and representations cost our country dearly. That was on Truth Social that Donald Trump said that. And even more tellingly and more compellingly, in this motion filed by the DA's office, they highlight the fact that Donald Trump retweeted, if you will, reposted a statement from a Fox News commentator about this. He said, they are catching undercover liberal activists lying to the judge in order to get on the Trump jury. Now, they is probably a broad reference to the process itself and the judges and maybe the lawyers themselves too. But the point of both of those and the additional 5 things that the DA has identified is all of them are violative of the order. And so, as I've often said on this broadcast in the past, Judge Merchan, our nation turns its lonely eyes to you. What are you going to do about this? What are you going to do to deter Donald Trump from doing exactly what you prohibited from doing? This is our first reference to deterrence on our weekend broadcast. You deter him specifically from doing this to ensure the integrity of that process going forward. And indeed, the judge is sufficiently concerned about it because he has scheduled a hearing for this coming Tuesday, and at that time, he is going to entertain this motion. Now, all of this is going to go ahead outside of the presence of the jury. Jury is going to know nothing about this at all, nor should they. They should become nowhere near this information. But during the course of that hearing on Tuesday, the judge is going to entertain argument and presumably maybe even some evidentiary presentations about what's happened here. And the advocacy I'm making this weekend on our broadcast is that he needs to do something. And that's not just a limp-wristed response to all this. We know that in the past, Judge Engeron has imposed some fines, several $1,000s. He was the judge presiding over that major fraud case involving the almost a $500 million judgment entered against Donald Trump. And those fines, again, attached to Donald Trump, wonder out loud whether fines do the job. The DA's office has asked likewise for Judge Merchan in this case to impose monetary fines. My advocacy this morning is to do more than that. And there is something that a judge can do. Finding a defendant like this in contempt of an order, which unmistakably he is. He is saying these things about witnesses, about jury members that are completely violative of the overt, you don't have to be a lawyer to know this, the overt terms and conditions of that order. And Judge Merchan needs to take some action. And what he should do, and this is on the possibility, his palette of options here, is to jail Donald Trump overnight. Not in the presence of the jury. You don't take him out in shackles in presence of the jury, just the opposite. But you put him in prison, in jail, in a lockup, in detention overnight, and that is your punishment. That's an attempt to deter you from doing the bad thing that you do. And every single time that you do that, you will get another night spent in jail. All of this, a part of our Case Notes advocacy here on our weekend broadcast, Amicus, a law review, which continues into our second hour.
You're listening to The Shaw at WAUK, Waukesha's home for the Devil's Advocates radio show.
The Todd Alba Show.
Who do you want making the decisions for your daughters if you're a girl dad? I have two girls, 14 and 12, and I still consider myself pro-life. But here's the thing. I became a conservative because I didn't want government telling me what to do and being intrusive in my life. And I'll be damned if I want a bunch of theocrats getting in the middle of my daughter's life.
The Todd Alba Show. Weekdays noon till 2 on your local Civic Media radio station and on the app. Busted Pencils with Dr. Tim and Dr. Johnny.
I wonder what Matt Damon's mom would say when it comes to teaching science to little kids.
Wait, what? You want to know what my mom would say? All right, well, just ask her.
And there she is, Dr. Nancy Carlson Page. Welcome to Busted Pencils. Nancy, how are you?
Hey, I'm great. It's great to see you. It's great to be here.
Busted Pencils. Fully leaded education talk. Weeknights at 6 on your local Civic Media radio station and on the Civic Media app. You're listening to The Shaw, WAUK.
This is Amicus, a law review, and my name is Jim Santelle. I am your host on this weekend broadcast as we finish up our first hour and go into our second hour, continuing talking about the major stories in law and government and the administration of justice, chatting in particular about this order and the violations of it, the unmistakable violations of this order imposed by Judge Juan Merchan to prevent the administration of justice from going awry at the start of this trial. The prosecution having filed this motion, 7 different instances of Donald Trump already violating the express terms and conditions of the order with respect to commenting about witnesses, commenting about jurors. And the question then before Judge Merchan is, what do you do about that? Well, again, he can impose fines, which is exactly what Judge Engeron did in that financial fraud case. And he probably will do that, maybe as a part of his graduated discipline, if you will, his graduated deterrence in this case. My suspicion is that is what Judge Merchan is going to do. And then as these continue to mount up, have another hearing. If there are more of these beyond 7, and likely during the course of the next 6 weeks, there will be more of them. My advocacy here as a part of our case notes commentary is just this, that in order to have an effective deterrent impact in any situation, in criminal justice, frankly, in other areas of our lives, there need to be consequences. We know that that's true when it comes to even raising small children. When we say that small children, if they have violated the rules of the household, there are penalties for that. That may be no video games, that may be no running around outside with friends after school, that kind of thing. And the concept is a good one there. It applies across the board to all of our lives, which is if something bad happens, then I know that there is a consequence to that, and my behavior in the future will be animated by my recollection of that bad thing that happened to me when I was punished for it. That's deterrence. That's specific deterrence of the sort that Judge Juan Merchan needs to embrace here. Unless Judge Juan Merchan does something, he is going to simply invite more of this misconduct and potentially taint the very process of the jury going forward. As I indicated, probably going to impose some fines initially and then graduate that over the course of time if there are more instances. My advocacy, because the terms are so clear, is for detention overnight. Put this defendant in jail overnight, and none of that is in front of the jury. They see nothing about this. He is not in shackles. During the course of that evening, he does not have access to his cell phone, cannot tweet. He can have access to his attorneys. He will be fed. He will have access to bathrooms, those kinds of things. But that is the kind of deterrent impact that a judge needs to be not only pondering but imposing to ensure that the rules of the trial are abided by, the rules of his order have some meaning to them, and absent doing something that has some punitive impact upon it, this kind of conduct will continue. And lest you think this is insignificant, the answer is just the opposite. Depending upon this kind of thing, we already know that we've got jurors out there who are concerned, as they said during the course of the jury deliberation, about disclosures made about who they are, where they work, where they live, those kinds of things. Safety and security, a huge issue. And we also know that Donald Trump will almost certainly have access to, in a way that we do not, We do not appropriately. We should not have access to who the names are, where they live, where they work, those kinds of things. But Donald Trump does, by virtue of his engagement with his attorneys. The attorneys on this case do have all of that. Heaven forbid that he should use any of that information in posting online, in saying casually outside of the courtroom, as he does, as he has these media conferences. Heaven forbid that he should do anything in that category that would compromise the safety and security of a juror. The safety and security of witnesses also, equally a concern here. And that's why Judge Juan Merchan needs to act and do something decisive. Again, is this the most dramatic thing that he can do? Probably so. Probably so. And would it garner huge headlines? Absolutely. Understand that completely. The first time in our nation's history that a former president has been detained, even overnight, for a violation not of the underlying charges, but for a violation of the rules of court. The rules that once again attend to every single other defendant out there in our nation. State courts, federal courts, all of that, the subject of appropriate deterrence with respect to this specific defendant, and also sending a message more generally to other defendants who are out there who in the state and federal courts of our land may be looking at this and saying, gee, if this particular defendant can get away with this, can say and post and do whatever he wants, maybe I can do that too. There needs to be that general deterrence for anyone else out there who might find themselves accused of a crime and brought into court, that they cannot do this. And again, that the rules of law, the rules of process and procedure cannot be different from defendant to defendant, even though we acknowledge all that this is an atypical situation. We have someone who is known by everyone. All the jurors understood that. Nonetheless, Judge Juan Merchan, we call upon you, I call upon you, as you go forward here and entertain these arguments on Tuesday, to consider the entire palette of options that you have. Fines, to be sure, and maybe you begin with those. I suspect he will. But that prospect of detention overnight, detention that would not, in fact, change the course of the trial, it would make it more difficult, undeniably, for his attorneys to have access to him. But that can also be arranged during the course of the evening hours in lockup. That can happen. That happens all the time in America. It needs to happen because absent that deterrent impact, the behavior continues. And that's what deterrence, specific and general, is all about. As we finish up this first hour, we do have a caller on the line. Jean from Eau Claire, thanks for calling in this weekend.
So much for taking my call. I really believe that one of those judges definitely needs to give Trump a real-life experience. Trump has never slept on hard beds, used toilets, been in a confined space, and not had people at his call. In all honesty, this would be a reality check, probably a gift to him, to realize the consequences that could happen to him for his behaviors. He's always been able to pay fines. He's always been able to, get people off, their cases, by money. This would be a gift to Donald Trump to realize what he is facing. And I think they need to do that for his benefit, because maybe we'd see a new Donald Trump. Thank you so much for taking my call.
Jean, thanks so much for the comment, the observation, with which, of course, I concur completely. That's another way of describing deterrence, right? And an interesting wrinkle on that, which is, of course, that may have an impact upon this defendant himself and maybe prompts some self-examination as well. One doesn't know, but that's the prospect as well. This is Amicus, a law review. We're going to continue in our second hour to move on to the United States Supreme Court, as we often do, talking about this major case involving Fisher and the election interference case in the District of Columbia, and then talking more in our weekend broadcast, all about deterrence here on the broadcast stations of Civic Media.
The Shaw, WAUK. Pat Kreitlow.
Monday morning, Selena Heller on the Birds migrating back to Wisconsin, and the Milwaukee Bucks begin their playoff series with Indiana.
Up North News with Pat Kreitlow. Weekday mornings starting at 6.
Hi, I'm Emily from Weichert Realtors Lake Point in Madison. Your home, your property, your decision. At Weichert Realtors Lake Point, we'll guide you every step of the way, whether you're buying or selling a home or exploring commercial property. Your dream is within reach. You'll find our realtors love what they do, and more importantly, we think it's fun helping our clients achieve their goals. Who wouldn't want to do that every day? Give me a call at 608-721-8002. Weichert Realtors Lake Point, 2045 Atwood Avenue. Find more info at weichert-lakepoint.com.
You're listening to The Shaw, WAUK 540 AM Jackson, W266DR Waukesha, and always streaming on the Civic Media app.
This is CBS News on the Hour, sponsored by Clean Origin.
I'm Linda Kenyon. Now that a jury has been seated, it's time for the next phase in the hush money criminal trial of former President Trump.
Full steam ahead for the prosecution come Monday when they will call their first witness.
CBS's Robert Costa. When it comes to the jury
set to hear the case includes a teacher, an investment banker, and a corporate lawyer. The assigned foreperson is originally from Ireland. 6 alternates are also on the panel in case jurors are dismissed.
That's CBS's Bradley Blackburn. It is a big day in the U.S. House, which is taking up 4 separate foreign aid bills.
The U.S. House is poised to approve nearly $61 billion in aid to Ukraine, along with billions to help Israel.
CBS's Scott McFarland says the Senate is poised to vote on those bills early next week. The UN Relief Agency's deputy director in Rafah says conditions there are getting worse.
Everything moves kind of at the pace of a donkey cart because the congestion of traffic is so bad. And what you have is people every day trying to find food, water, and now trying to find shade as the temperatures increase and we move from winter to summer.
Scott Anderson spoke ahead of what is expected to be an Israeli ground assault of Rafah. The U.S. and other nations have been trying to discourage that action. Employees at a Volkswagen factory in Chattanooga, Tennessee have overwhelmingly voted to join the United Auto Workers Union. UAW President Shawn Fain was on hand to celebrate the union victory.
Well, we've heard for years that we can't win here, you can't do this in the South, and you can.
And Fain says the vote is symptomatic of a larger sentiment among workers.
Workers are fed up in this country. They're fed up with being left behind, with our win in Big Three bargaining. I think that really motivated a lot of workers to realize there's better for them.
This is an historic first test of the UAW's renewed effort to organize non-union factories after a successful confrontation with Detroit's major automakers. Today marks 25 years since 2 students killed 12 other teenagers and 1 teacher at Columbine High School in Littleton, Colorado. Among those speaking at a vigil last night, former Arizona Congresswoman Gabby Giffords.
Change doesn't happen overnight, and we can't do it alone. Join me, let's move ahead together.
Greffords was gravely injured in a mass shooting in Tucson, Arizona in 2011. It happened as she was meeting with constituents at a congressional event outside a grocery store. It could soon be pandemonium in San Francisco. China is sending the local zoo there some panda bears, and these folks are looking forward to it.
It's super exciting, honestly.
We're excited. I think it'll bring more people out here, and the zoo needs some help. I haven't seen a panda ever, if I remember, so it'll be fun.
The NBA playoffs could be fun. The first round begins today with 4 games, including Orlando at Cleveland and Boston against Miami. This is CBS News.
Don't pay retail for diamonds. Come to CleanOrigin.com, the lab-grown diamond experts. Mention code radio10 for 10% off. CleanOrigin.com, online or one of our retail stores.
This is Civic Media News. I'm Terry Bell. Federal incentives are helping pay for new renewable energy projects in Wisconsin. Here's Mike Moan with more.
Dane County is no stranger to embracing clean energy, but federal aid from policies like the Inflation Reduction Act and bipartisan infrastructure law spurring more activity. County Executive Joe Parisi says there have been past government credits for things like solar installations, but he adds the latest approach is more expansive.
Everybody, a business, a nonprofit, a church, a temple, even a government and a local government gets 30% back on renewable energy projects.
For example, a local construction company put solar arrays on several of its facilities. He says the new credits speed up the pace of reimbursements, creating more energy savings in the near future. Federal officials say demand has been strong for programs offering the aid, but Parisi says one challenge is creating broader awareness so that under-resourced areas can apply. Beyond clean energy, Parisi says the federal government's push for more made-in-America manufacturing creates opportunities for local plants and regional economies.
There's money available to help retooling to manufacture, and then there's a stronger market for those components now because they are made in America.
National polling shows Americans are greatly concerned about things like inflation, but Parisi says these long-term investments stand to help reduce operating expenses for government agencies and businesses, hopefully keeping local taxes in check while providing savings for consumers. This is Mike Moen for Wisconsin News Connection. Find our trust indicators at publicnewsservice.org.
You're listening to Civic Media News. I'm Terry Bell.
Your news, conversations, and a whole lot of fun. It's all on your local Civic Media radio station or the Civic Media app.
With your forecast, I'm Corey Hartman. For today, mostly sunny, highs near 48, frosty tonight, low 30s. For Sunday, sunshine and highs in the upper 50s. Clear skies, a low of 37 for Sunday night. On Monday, some sun and clouds and a high near 62. Rain showers likely Monday night into Tuesday.
Right now, 35.
Crude and Dom.
The trial of the century has begun. Donald Trump, defendant. Tune in to The Devil's Advocates. We'll have all the opening statements and first aid testimony.
The Devil's Advocates. Weekdays 4 till 6.
You're listening to The Shaw, WAUK, Waukesha's home for Matt and Air on Air.
This is Amicus, a law review. My name is Jim Santelle. I am your host for this, our second hour on our weekend broadcast. As always, talking about the major news stories in law, in government, and the aspiration for justice in America and beyond. This weekend, spending a lot of our time in our first hour, just now concluded, talking about this precedent-setting trial going on in Manhattan, the trial courtroom of Juan Merchan, chatting about not only the selection of jurors there, who they are, some of the challenges there, but also challenges related to the administration of justice by the judge himself with respect to the defendant and the things that he is saying and doing outside of the courtroom and even inside of the courtroom. We know during the course of this week, during the course of the jury selection itself, there were some behaviors that the judge likewise noted and disapproved of. On Monday, Donald Trump was witnessed sarcastically chuckling when the judge noted that he would be in charge of sentencing should Donald Trump be convicted. And then again, when Judge Merchan said he would conduct a fair trial. On Tuesday, one day later, Judge Merchan reprimanded Trump for another interruption, another interjection in the course of the process. On this occasion, Donald Trump said something that the judge suggested appeared to be directed at one of the prospective jurors. This is going on here during the course of the selection itself. After one of the prospective juror was dismissed, Merchan quickly addressed Trump attorney, a fellow named Todd Blanche, whose name you probably have heard a lot. Merchan noted that the prospective juror was about 12 feet from your client, sir, he said, and that Donald Trump was audibly uttering something toward them. He was audibly gesturing, speaking in the direction of the juror. I won't tolerate that, the judge said. I will not have any jurors intimidated in this courtroom. I want to make that crystal clear. Well, once again, I invoke that language from Judge Merchan just in response to Donald Trump's behavior because it should be Judge Merchan's commission going forward this week to do not only enforce that understanding of the rule of law, but also the letter, the terms, the conditions of the order that prevents him, that is Donald Trump, and prevents, once again, every other defendant out there from commenting about the witnesses and commenting about the jurors. Now, what Donald Trump can and does say, and this is completely within his right to do so, is he can talk about how he is not guilty, how the prosecution will not be able to prove its case beyond a reasonable doubt. He can talk about the unfairness generally, if you will, generically. Even those things, candidly, most defense attorneys will tell you they would prefer their clients not do that. But those do not go to the specifics of individuals, the witnesses, the jurors themselves. Those things probably permitted under the relatively narrow terms of this order. But the order has been violated, according to the DA, no fewer than 7 times in recent days. the judge, Judge Juan Merchan, needs to act and needs to act for the deterrent purpose of ensuring the legitimacy of this process going forward. We spend most of this hour, their second hour in our weekend broadcast, talking now about the United States Supreme Court. What's going on there? What couple of decisions made by the Supreme Court just in this past week? Things on the docket. And in that connection, before we get to that, let's do a little bit of a calendaring for the coming week at the top of this, our second hour. We know once again that on Monday, the trial resumes with opening statements in that Manhattan courtroom, the attorneys telling the members of the jury what they expect the evidence will say. These are not arguments. They're statements about plans for witness presentations. They're not to be argument. And actually, it can be objectionable if indeed you're arguing the case from the start. It's a plan, sometimes said it is a puzzle piece you're putting together, a roadmap, that kind of thing, telling the jury, giving more flesh to the bones, if you will, about what the judge said this case is all about. That happens on Monday morning. On that same day, another courtroom, again in the Manhattan state court trial proceedings, Attorney General Letitia James is going to be going back into court. Different case. This is the valuations case. She's going to be challenging the bond that was posted by Donald Trump to secure his appeal in that $500 million valuations judgment entered by Judge Engoron. The story there, you know well, the appeals court reduced the bond dramatically, also stripped away some basic core elements of the judgment entered by Judge Engoron. And now the Attorney General going in and saying the company, the agency, the association that's coming forward with this bond, unlicensed to practice in New York, therefore the bond should be rejected. That's going on Monday. Another courtroom, also in New York, lots of activity in the judicial realm in New York City on Monday. On Tuesday, the 23rd, again, Judge Merchan going to be hearing this argument about whether or not the court order not to comment on jurors and witnesses has in fact been violated, and we look to him to see what he does to promote deterrence. On Wednesday, the United States Supreme Court is going to be hearing oral argument in, yes, an abortion case called Moyle. It has to do with the intersection between a state and a federal law on abortion, and in particular, a particular federal law that, as interpreted by the Biden administration, requires that in emergency situations, pregnant women who are patients, that the medical emergency staff there is obliged under appropriate circumstances to engage in emergency abortion services. Now, the state legislature has challenged that federal law, again, the federal law that's passed by the Congress itself under something they call the Idaho Defense of Life Act. This passed by the state legislature, and that Defense of Life Act establishes, according to Idaho law, that no abortions can be conducted. And the question is, which one of those holds sway? Which one of those is the most important? The determination before the Supreme Court is whether or not this Emergency Medical Treatment and Labor Act, the EMTALA, that's the federal statute that, again, requires hospitals to provide necessary stabilizing treatment to pregnant women in emergencies when those circumstances arise under emergency abortion situations. Where's the conflict? And is there a conflict? There seemingly is. How do you resolve the conflict between that federal law obliging medical staff to engage in the life-saving treatment as opposed to the state law that prohibits abortions generally? That's being argued this coming Wednesday, the 24th. And yes, on Thursday, the 25th, in the United States Supreme Court, the following day, the last day of its oral argument this term, the Supreme Court is going to be entertaining this all-important immunity discussion on whether or not the chief executive, Donald Trump, in this particular case, is immune for activities, behaviors in which he has engaged in the inner parameters of the circle of official duties. And of course, his allegation is that he cannot be prosecuted in federal, arguably state court as well, because he's the president of the United States of America, and the president should have immunities from any such prosecution. That is a frivolous argument. There cannot be that basis in modern jurisprudence. In historic jurisprudence, we do not have kings in America. It is a frivolous argument. Nonetheless, the Supreme Court is going to be taking it up on Thursday. Listen to that oral argument. Anticipate, hopefully, that every member of our Supreme Court is not only skeptical, but dismissive of this notion that somehow there's an omnibus broad immunity that applies to presidents. That coming up on Thursday, the 25th, in front of our United States Supreme Court. It is a busy week coming up, and we're going to talk right after our next caller about another case that was argued just this past week. That is the Fisher case. And so that issue also related to the federal interference case pending before Judge Tanya Chutkan in the District of Columbia. We're going to talk more about that, go into a deep dive on that, some microscopic justice, but what the Supreme Court justices said and what they didn't say. All of that in the midst of our weekend discussion that includes you and that includes our listeners, 844-967-2789. And yes, Joe, this morning it includes you as well, calling in from Madison. Joe, glad to hear from you once again.
Thank you so much for all the information. I was particularly intrigued by the course of action that you spoke of in the last hour. If Mr. Trump continues this action of putting the members of the jury, the witnesses, and the judge and his family under a threat of other people committing violence against them. And it's a very mob move, I think, to sort of suggest that these people may suffer consequences if they don't go the right way. You had suggested that one way that the judge might tackle this is first by fines, saying, you cannot engage in material or actions that threaten these people. But you also suggested there was a possibility of also jailing the ex-president overnight and then bringing him back. I'm curious about two things on that, Jim. First off, I had heard that some had speculated that the Secret Service would never go for this because it would be too complicated. And I thought, well, geez, I don't see why it would be so complicated. And the second thing I would ask is, you had suggested that the jurors, if the judge were to say you serve overnight and then come back the next day for trial, the jurors wouldn't know what had happened. I think in some ways, wouldn't it be useful that the jurors know this? Wouldn't they feel more secure and safe knowing that their concerns about safety had been addressed and taken seriously by the judge? I'll take my answers off air, and I thank you very much for pursuing this. Thanks.
Very good. Joe, thanks so much for, again, a couple of great questions there. Let's take them in that order. And again, the advocacy from me. I recognize that other rational people out there can differ. That's what America is all about, is for deterrent purposes that, yes, indeed, Judge Juan Merchan, at least at a minimum, needs to engage in some graduated discipline here, maybe fines first, Joe, as you indicated, and then detaining the defendant overnight. That's the deterrent impact that you have upon a defendant who continues to violate the rules of the court. With respect to the trappings of that, I know nothing about it. My guess is that probably court officials have begun to think about this. Where would that happen? Plainly could not be at Rikers or some other place of general population. But the Secret Service, frankly, the orders of a court are orders of the court. And the Secret Service and others who are responsible for providing safety and secure passage and the safety and security of a former president, yes, that's Donald Trump, they are obliged to follow the orders of the court. Undeniably would probably engage with him in the trappings of that. The location of that would not be known. Other things to ensure that this does not happen in a public domain. But again, I've had many circumstances in my own career where judges order marshals and others to do things by virtue of their authority in the court. It is the order of the court, and they're obliged to do it under those circumstances. Interesting, and that is this importance from my perspective, and I think from most jurists out there. I'm not a judge, but other practitioners out there who would say that the jury should not know about what's happening with this particular defendant coming in and out. Certainly never see the defendant himself, in this case, in shackles or being visibly escorted into and out of the courtroom by law enforcement authorities. We are going to talk about that all-important issue as our discussion this weekend on Amicus continues. And the question, once again, is what are the upsides, the downsides of a jury knowing that? Joe indicating that there may be some interest in the jury knowing that they're safe and secure, at least the judge is doing that. I'll address that as well as our discussion here on our weekend program continues.
This is the Shaw, WAUK.
Get ready to ignite the ultimate 420 celebration at Turning Leaf in Waukesha with a smoking hot deal you can't miss. For one day only, Turning Leaf is offering a mind-blowing 40% off everything in store related to CBD. Yes, you heard that right, 40% off. Come spin the prize wheel for a chance to win some serious swag and sample anything and everything in store. Mark those calendars for 420 and take a trip down to Turning Leaf at 450 West Sunset Drive in Waukesha to take advantage of the highest deals of the year.
Do you owe back taxes? Call Tax Solutions now and get some help. For a limited time, the IRS offers a tax forgiveness program called the Fresh Start Initiative. Our team can make it easier for you to pay back taxes, avoid tax liens, and get a fresh start.
I call Tax Solutions now, and they got the IRS off my back.
Call Tax Solutions now. 800-281-8193. 800-281-8193. 800-281-8193.
The Shaw, WAUK, Waukesha's home for Nightlight with Peach Waba.
281-8193.
The Shaw, WAUK, Waukesha's home for Nightlight with Peach Waba.
281-8193.
This is Amicus, the Law Review, and my name is Jim Santelle. I am your host in this, the second hour of our weekend broadcast, and we're entertaining, as always, your questions and comments. Joe articulating this great question about the circumstances, if ever, that a jury should know following the, I'll call it the Santelle recommendation this weekend for the time-limited detention of a defendant who continues to violate the rules of the court. And so what I was articulating is this notion that while the jury is in process during the course of the presentation of the evidence, the defendant is there, he is not shackled, he is not in custody, but after the jury leaves and after the proceedings are done, is in fact brought into custody and remains there overnight, access to your attorney, access to family, access to bathrooms and personal care matters, all those kinds of things. But that is the detention that is necessary to promote the deterrent impact of what the judge is trying to accomplish. And so Joe asked this very good question. Well, gee, wouldn't it be appropriate for the jury to know that the judge is doing something to address their safety and security? And the answer is yes and no. And so what the judge should do, if in fact this continues to percolate up, is deliver a very broad instruction to them. Let the jury know, and again, this would be on the record, that the judge is aware of concerns. And again, you have to be very careful about describing these things. You don't want to inflame them. You don't want to excite them or make them even more anxious than they are. But recognizing that there's a huge amount of focus, as he has already done, that there are concerns about safety and security and concerns about notoriety and publicity about this lawsuit, and that the judge is doing things that, unfortunately, he cannot tell them about to ensure that those interests are met. You don't want to tell the jury that this particular defendant is in detention when he is not in the courtroom. Why? Because that would tend to suggest you don't want to influence in any way the notion that this defendant is presumed innocent until proven guilty, that he's presumed innocent throughout this process, and don't even want to suggest that somehow there is something about this defendant, his behavior, his conduct, whatever that may be, that now puts him in a detention facility. You don't want to have that information impacting, affecting, infecting, if you will, the process by which the jury assimilates and takes in all this information. And so routinely, whether it's a trial, a sentencing in federal or state court, the juries do not see that. You do not want to send them that message that for some reason this particular defendant is in custody. So it is a great comment, a great question. The jury should know that the judge is concerned about this. He's already done that, and he can do that with a cautioning and also an advisory instruction. And then, outside of the presence of the jury, as he has done, can continue to admonish the defendant and continue to admonish his attorneys to ensure that they are also following the rules of this trial. And Judge Mershon will certainly continue to do that. It is difficult to imagine that this behavior will stop and will not continue as this trial goes forward. Great questions. Also have a caller, Kristen, calling in from Waukesha. Kristen, glad to have you with me on our discussion this morning.
Good morning, Jim.
Good morning, Kristen.
My question and concern is that either Trump or his attorneys, or them in collusion with each other, will purposely leak the names of the jurors in order to upset and delay or cause a mistrial or something. What would happen if they do that?
Right. That is, all these things, Kristen, you raise these possibilities. And again, begin with the notion that every lawyer is an officer of the court. And what that means is you are obliged to follow the rules, the regulations, the things that the judge has said. Part of that is that we're disclosing to you the names of these jurors, and yes, maybe even where they live and their work addresses, those kinds of things. You are under an absolute command not to disclose those. And so your hypothetical, which would be horrific, if in fact the attorneys do that, if in fact Donald Trump does that, that is contempt. And once again, you'll have another hearing on that sort of thing. And not only will the judge have some authorities to fine attorneys, arguably, once again, if you are in contempt, a criminal contempt proceeding, one of the other remedies, once again, is detention. It is putting someone, depriving them of their liberty. And from time to time, it is rare, attorneys have been jailed for failing to abide by the terms and conditions of an understanding in a trial. It is very rare, but it can happen as well. That's the deterrent impact as well, because you're an officer of the court, because then you have truly compromised the trial itself. And of course, the other part of this, which may sound somewhat less dramatic, is someone doing something that dramatic is also going to get a letter from the Office of Lawyer Regulation, the bar people, saying you have now violated the rules of the court. And we're going to take a look at your bar license for doing that. That's the reason why all those folks affiliated with Donald Trump in connection with the maintenance that the 2020 election was stolen, that's why they're in so much trouble out there. All that's a remedy. That is the concern. And the judge, as this, again, if this was a few days, our concerns might be less significant. I think, Kristen, you're concerned about this going on for a long time and the possibility that at any time during the course of the next 4 or 5, 6, 7, probably not 8 weeks, but a long period of time here, any of those things could somehow be leaked. The question then is, what do you do about that? The other concern about it, the reason why this is so important, is that with that, you may indeed have a mistrial. If you have jurors who come forward and say, you know what, I am now in fear of my life because my information has been disclosed, and you drop below that 12 threshold, which we talked about in our first hour this weekend, if you drop below that, then you've got a mistrial and you start all over again. The case is not dismissed, but that's the kind of thing, that's the dramatic consequence of misbehavior if, as an officer of the court, the lawyers are not behaving well. Admonishment, bar review, and the possibility of fines and detention for them as well. Lots of consequences, lots of things we hope doesn't happen in the course of this trial, but it is a long trail coming up in the next few weeks. Lots of evidence to be presented, and undeniably, with respect to the defendant's murmuring in court when he has with the jurors in front of the judge noting that if there are additional comments like that, as for example, the witnesses, including Stormy Daniels and Michael Cohen and others, take the stand, if Donald Trump is visibly and orally in particular saying things about them in the presence of the jury, that will prompt the judge to dismiss the jury for a few moments or maybe even an hour or so and have another hearing on that. You don't want any of that to happen in front of the jury, again, to taint their view of the defendant, to taint the process. But it does require some response by Judge Merchan, and that more than anything else is the articulated mission and articulated encouragement, if you will, from me to this court as we go forward. We are talking again in this, our second hour, about the United States Supreme Court. Again, another case pending in front of Judge Tanya Chutkan. This is the election interference case. It is pending before her, but we know it's been suspended. Why? Because of two cases pending in front of the Supreme Court. One in particular, that is the immunity case. It's going to be argued on Thursday, the 25th. We'll see what the justices do. They need to return a decision finding that the defendant is not immune and sending that case back to her. But there is the second case involving Fisher, and that case was argued just this past week, a case involving Joseph Fisher, who did in fact engage in the riot on the grounds of the Capitol on January 6th. We're going to talk about what Mr. Fisher did, and especially what the Supreme Court said in connection with its oral argument on the legitimacy of the statute being used to prosecute Mr. Fisher. And yes, also, this is the connection, a statute also being used to prosecute Donald Trump, as Amicus, a law review, continues.
You're listening to The Shaw, WAUK.
CBS News Brief. On Monday, there will be opening statements in the first witness in former President Trump's hush money trial. Trump watched closely as jurors were chosen, and some said serving was too much for them. CBS News legal analyst Jessica Levinson.
The jurors understand that they are weighing in on not just the facts presented to them and the law, but a historic decision.
The U.S. House votes this afternoon on 4 foreign aid bills for allies, including Ukraine. Democratic Maryland Representative Jim McGovern.
The world is watching. It is time for Congress to act.
A big victory for the United Auto Workers Union as employees at a Volkswagen plant in Chattanooga, Tennessee, vote overwhelmingly to join. This man was among those who voted.
I was really inspired by watching Sean Fain and the UAW and the Big Three contracts. You know, we all kind of look, we can obviously be doing way better than this.
The UAW has been working across the nation to organize non-union factories. CBS News Brief. I'm Allison Keyes.
The Brewers escape a close call. Hi, I'm Mike Clemens with sports. Brewers pitcher Freddie Peralta was covering home plate while his catcher was chasing down the baseball. Cardinals base runner Wilson Contreras crashed into Peralta trying to score. That's the last thing the Brewers pitching staff needed. Here's the play on Bally Sports.
A swing and a miss. It gets by Contreras. Freddie covering home plate. There's going to be a play, and Contreras is out. Wilson just flat out tackled Freddie Peralta at home plate. They're going to get it out at home, and that's going to end the inning.
The game went into the 10th inning in St. Louis when the Brewers' William Contreras drove in the winning run for a 2-1 win for Milwaukee. Manager Pat Murphy after the win at Busch Stadium.
Freddie and Contreras were unbelievable. William on both ends. You know, the big double and the big single. What can you say? He's clutch. Big game, 1-0 game. Just spectacular. And Contreras he earned his money tonight. He's going to earn a lot more, I promise you.
That's the Brewers' Pat Murphy. With sports, I'm Mike Clemens.
With your forecast, I'm Corey Hartman. For today, mostly sunny, highs near 48, frosty tonight, low 30s. For Sunday, sunshine and highs in the upper 50s. Clear skies, a low of 37 for Sunday night. On Monday, some sun and clouds and a high near 62. Rain showers likely Monday night into Tuesday.
Right now, 35.
Flood risk can change over time, and a community's flood insurance rate map shows how those risks could affect you. FEMA, the Federal Emergency Management Agency, has developed preliminary flood insurance rate maps for Washington County. FEMA also provides an appeals process for anyone with information that may change their flood hazard determination. To view maps, find your property's risk level, and details on the appeals process, please visit dnrwi.gov and search Washington County flood maps. This message is brought to you by the Wisconsin Department of Natural Resources and FEMA.
Are you and your family weather ready? I'm Terry Barr, producer of the Slice of Wisconsin series. Wisconsin weather is ever changing, and all of us with civic media believe awareness can make a difference. Our weather ready stories will offer the information you need. Here's meteorologist Brittany Merlot.
Are you making plans to honor Mother Earth? April 22nd is Earth Day, and it's a Wisconsin idea. Our Senator, Gaylord Nelson, created the day in 1970. It was his way of pushing environmental issues onto the national agenda, and many demonstrated in support. It worked. The U.S. Environmental Protection Agency formed by December of that year, and today, Nelson's daughter Tia continues her dad's efforts. The Earth Day theme this year focuses on the use of plastics. It includes a reminder of the goal for a 60% reduction in the production of plastics by 2040. If you want to find a cleanup or education event to help during Earth Day week or anytime, check earthday.org. I'm meteorologist Brittany Merlot.
Hey, so what's a great way to spread awareness that driving high is illegal everywhere? A catchy song, of course.
You can run, but you can't drive high. You can run, but you can't drive high.
Friendly reminder, don't drive high. If you feel different, you drive different. Brought to you by NHTSA and the Ad Council.
Earl Ingram.
Monday morning, join me as I stroll through memory lane and take in the sounds of the Motor City. It's Motown Mondays.
The Earl Ingram Show, weekday mornings 8 till 10.
This is Amicus, a law review. My name is Jim Santelle. I am your host in this, our second hour of our weekend broadcast about things related to government, law, and the aspiration for justice in America and beyond. It has been, and it will be, a busy week for the United States Supreme Court. In addition to having entertained oral argument in a case we're now going to discuss, Supreme Court also issued two more important decisions this past week. A couple of rule of law snapshots right here. Both of them important in their particular areas. A case called Rudisill versus Donahue. Rudisill versus Donahue. The question is whether or not veterans can partake of educational benefits under two different veterans programs, the Montgomery Bill and the GI Bill. 7-2. 7-2. The Supreme Court says, yes, indeed, veterans can, in fact, take benefits under both programs. It is a win for veterans. It's a win, I would argue, for all of us. Appropriate decision. Rudisill versus Donahue, 7-2 just this past week. And then another case also related to benefits and the possibility of securing an employment discrimination judgment against an employer under Title VII of the Civil Rights Act of 1964. This is a case called Muldrow versus City of St. Louis, a police officer coming forward and alleging some discrimination in the context of her movement from one assignment to another. And again, without going into great detail, a 9-0 opinion just this past week from the Supreme Court, all of them unanimously saying that this particular officer and all of us now going forward under Title VII only have to show some harm from the decision, do not have to show some significant disadvantage by virtue of the employment decision that was made, kind of redefining the statute, redefining the standard under which employment discrimination cases in the federal system can go forward. Both important decisions in the area of veterans benefits and the programs that we appropriately afford our veterans, and also under Title VII, employment opportunities and opportunities also to remedy discrimination. Those two cases coming out of the Supreme Court just this past week. Also coming out of the Supreme Court, of course, not with a decision, but with oral argument on Tuesday involving a case named Fisher. Now, we know from the past, we know from the history of this case, which we have talked a lot about, and Mr. Fisher, who is one of quite literally over 1,000 defendants now being prosecuted by the D.C. U.S. Attorney's Office under the rubric of the Department of Justice. He had sent text messages to his boss, who's the police chief of North Cornwall Township in Pennsylvania, about his plans for January 6th. And Fisher had said it might get violent, he said. In another, he wrote that we should storm the Capitol and drag all the Democrats into the street and have a mob trial. Prosecutors also said during the course of this prosecution that Mr. Fisher was yelling charge before pushing through the crowd, and he entered the Capitol about 3:24 on January 6th. He used a vulgar, incendiary term to berate some police officers, crashed into a line of them, and according to the government's position on this, was forcibly removed about 4 minutes after entering. A violent encounter by any measure of the facts in this case. Now, what happens is that the D.C. U.S. Attorney's Office charges him for that conduct, charges him actually with 7 counts. A number of them, 6 of them in particular, focused upon the violent nature of that behavior. And so those counts are not the subject, centrally at least, in this case, now pending before the Supreme Court, because what Mr. Fisher says is he is charged, among the other cases, among the other matters, under Section 1512 of Title 18. And yes, this gets a little wonky, but we do that here in our Civics Focus on our weekend broadcast. 1512 basically says this: whoever corruptly is the word that the Congress has used, the legislature has used to describe this conduct, alters, destroys, mutilates, or conceals a record, a document, or some other object with the intent to impair that object's integrity or availability for use in an official proceeding, or and there's a second subsection now, it says, otherwise obstructs, influences, or impedes that official proceeding or attempts to do so. 2 portions of this statute under which Mr. Fisher is charged. And the prosecution says we're charging him under the second portion of that alleges an otherwise obstructive behavior, otherwise obstructing, influence, or impeding an official proceeding. And what is the focus of that? By virtue of what Mr. Fisher has done, he was obstructing, influencing, and impeding the official proceeding of the counting electoral votes, right? Nancy Pelosi and Mike Pence counting electoral votes on January 6th. That's the official proceeding. That's the rubric under which Mr. Fisher is charged. Mr. Fisher comes forward and says, no, 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 no. I cannot be charged under 1512 because that's not what the statute means. He goes back and he says that this statute, and he's right about this, was passed as part of the Sarbanes-Oxley Act in the wake of the Enron scandal of many years ago, 2002, and about that time, the Congress comes back and passes legislation to prevent that kind of mismanagement of finances and of transactions, including documents. And the statute, plainly in its principal iteration here, talks about destroying, mutilating documents and records. And Mr. Fisher says, I did none of that kind of a behavior at all. This statute, he says, under the Sarbanes-Oxley Act, intended to focus on people who destroy materials. I didn't do that, and therefore the statute is inapplicable to me, and the charge against me under this particular statute should be dismissed. And he also goes on to say that the second portion, the otherwise obstructs portion of it, is dependent upon the first portion of that statute. The two cannot be read in separate iterations. They've got to be understood together. That's the basic context in front of the United States Supreme Court that is now determining whether Mr. Fisher's case, at least with respect to this particular charge, should be upheld or not. And so what we got on Tuesday before the United States Supreme Court was oral argument about Mr. Fisher's case, and yes, arguably with respect to about 300 other people also charged among the approximately 1,200 charged altogether for violations of this particular statute. 300 of the 1,200 also find themselves on the receiving end of a Section 1512 charge. So it has a dramatic impact upon them as well, not just Mr. Fisher, but also, as we have repeated on this broadcast and repeated again this weekend, it has a dramatic impact potentially upon the prosecution of Donald Trump in the federal district court for election interference pending in front of Judge Tanya Chutkan. The case suspended once again by virtue of the immunity argument and arguably this Fisher case as well. Why? Because 2 of the 4 counts against Donald Trump also are brought under Section 1512 of Title 18 of the United States Code. Now, there are 2 other counts also against Donald Trump, and those are conspiracy to defraud the United States and conspiracy to interfere with constitutional rights. Both of those cases, both of those charges would survive any attack under Section 1512, and those would remain. But plainly, depending upon what the Supreme Court does in connection with Mr. Fisher's case and its interpretation of the breadth of the strength of Section 1512, what does this statute really mean? Does the government's interpretation of this otherwise engaging in obstructive activity, is that what we should focus on? Or should we focus on the documents aspect of this, in which case 1512 would not apply? Well, just this past Tuesday, we got a very good sense that the Supreme Court, yes, that's right, is probably going to side with Mr. Fisher. By my count, about seven of the 9 justices looking at this case based upon their questions and comments are tremendously skeptical of what it is the government, through the Solicitor General, is advocating for. Clarence Thomas says there have been many violent protests that have interfered with proceedings. Has the government applied this provision to other protests? Sonia Sotomayor, on the other hand, took a different view of what happened on January 6th. She and Elena Kagan, probably the 2 who would go in the opposite direction and support the government's interpretation of Section 1512. Sonia Sotomayor says, we've never had a situation before where there's been a situation like this with people attempting to stop a proceeding violently. But the reality is that Sonia Sotomayor and Elena Kagan are probably in the minority based upon the questions that came forward. Chief Justice John Roberts said that the so-called catch-all provision, that is the second portion of this statute that talks about otherwise obstructing, influencing, or somehow impeding an official action, he said it's got to be read in context. Since the January 6 defendants were not accused of altering evidence, he said, the catch-all provision does not apply. That's a pretty clear articulation of his view that the government's going to lose in this particular case. It goes on. It goes on. Other justices likewise indicating their skepticism about the government's position. Neil Gorsuch asked, would a heckler in today's audience qualify? Or at the State of the Union address, would pulling a firearm before a vote qualify for 20 years in federal prison? He said, would a sit-in that disrupts a trial or access to federal courthouses, would that qualify as well? All of these questions coming out of the United States Supreme Court oral argument on Tuesday. Sam Alito allows that what happened on January 6th, he says, was a very, very serious matter. But he added that the prosecutor's theory could reach, say, protests in the Supreme Court courtroom, which have occurred from time to time. And Elizabeth Prelogar, again, those of you who listened to me in the past know that I think the world of her. She is our U.S. Solicitor General. She is articulate. She has a command of the facts. She is compelling in her presentation, and she does an outstanding job on behalf of the people of the United States of America and the Department of Justice. She refocused the efforts of the Supreme Court to figure this out. She said on January 6th of 2021, a violent mob stormed the United States Capitol and disrupted the peaceful transition of power. She went on to say many crimes occurred that day, but in plain English, the fundamental wrong committed by many of the rioters, including this petitioner, including Mr. Fisher himself, was a deliberate attempt to stop the joint session of Congress from certifying the results of the election. That is, they obstructed Congress's work in that official proceeding. She is tracking there plainly the second portion of the statute, this catch-all provision that many members of the Supreme Court, a majority it appears, are skeptical of. Amy Coney Barrett also asked how to distinguish the attack on the Capitol from other actions that have disrupted other official proceedings. She's asked this. She said, tell me why I shouldn't be concerned about the breadth of the government's reading. And indeed, it goes on. Brett Kavanaugh asked why the other charges weren't sufficient. That is, he's charged in these 6 other counts. They allege some violent behaviors. And he says, why couldn't we just go ahead with those? Why aren't those 6 counts, he says, good enough from just the Justice Department's perspective, given that they don't have any of these hurdles? Well, again, Elizabeth Prelogar pushes back on all of this. But the takeaway from the oral argument on Tuesday is unmistakably that the Supreme Court has great doubts about the application of 1512 to the Mr. Fishers of the world. And again, not just him, but 300 others. And the major question now before the Supreme Court is how to style its response. We're going to assume, for purposes of our continuing discussion here in our broadcast, the Supreme Court probably in June. We're not going to hear about this until, say, early to mid-June, maybe before that, but probably mid-June or so. The Supreme Court is going to tell us that 1512 cannot be applied. And so it will have a dramatic impact upon many of those prosecutions. It will involve revisiting those cases and determining whether or not there is a sufficient basis to continue with the convictions that were a part of the judgments. In Mr. Fisher's case, again, would not prevent the further prosecution of him under those other counts that Justice Kavanaugh was talking about. So it doesn't shut all this down, but requires some revisiting of the ways in which these cases have been prosecuted. And this is the point. The point as to Donald Trump is that depending upon what the Supreme Court says about the breadth and the mission, the purpose of Section 1512, it could also have an impact upon the continuing prosecution of the case in front of Judge Tanya Chutkan. Now, significantly, very importantly, anticipating that this might happen, we know from some past comments, some past writings of his, that Jack Smith, who's the special counsel in that criminal prosecution of Donald Trump, again, in the federal court, not the state court, the federal court in the District of Columbia, that Jack Smith has already said, I've got theories. And even if the Supreme Court finds this to Mr. Fisher and others, that second catch-all provision does not apply, does not mean that the 2 counts under which Donald Trump is prosecuted, those would go away. And he would argue that plainly in front of Tanya Chutkan. And all of that leads to the other consideration related to the timing of the trial before her, assuming some decisions in the immunity case and the Fisher case in June of this year. We're going to talk more about those on our weekend broadcast as Amicus, a law review, continues.
You're listening to the Shaw, WAUK, Waukesha's home for Up North News Radio.
Most of us agree that every Wisconsinite deserves affordable health care. California mega millionaire Eric Hovde does not. Hovde said he would repeal the Affordable Care Act, quote, in its entirety. What? The Affordable Care Act protects people from insurance companies refusing coverage for pre-existing conditions and stops them from dropping your coverage if you get sick. If Eric Hovde got his way, millions of Americans could get hit with increases in their healthcare premiums of 20% or more. Millions more could lose coverage altogether. Hovde even spoke out against parents helping their kids by keeping them on their health insurance plans until they turn 26. Now that might be okay for Eric Hovde. His businesses have raked in millions of dollars in handouts. But it doesn't cut it for hardworking Wisconsinites and our families. Call Eric Hovde at his California office, 714-730-4444. Tell him we support lower health care costs. Paid for by Better Wisconsin Together Incorporated.
The Shaw, WAUK.
This is Amicus, a law review. My name is Jim Santelle. These are final moments of our weekend broadcast, talking all about the implications of the United States Supreme Court decisions in these two remaining cases that arguably, in one case plainly implicate Donald Trump and the prosecution there in the District of Columbia. The second one, Fisher, that we described, also arguably having an impact upon that. Let's talk about the process that would come out of a decision by the Supreme Court, say in June, that finds that 1512 is narrower in its application than what the government, through the D.C. U.S. Attorney's Office or the Department of Justice, has previously articulated. What would happen is that plainly the attorneys, could be the prosecution, could be the defense, depending upon what the Supreme Court says, would file a motion. Arguably, the defense would file a motion to dismiss the cases, those two counts involving 1512. Jack Smith would push back on those and would maintain, no, there's nothing about the Fisher decision that would require the dismissal of those cases based upon what he has said previously. And so we would have more briefings in front of Judge Tanya Chutkan about this all-important issue, about what the impact of a Section 1512 decision coming out of the Supreme Court in June would have on his case. Does it require that she dismiss those other two counts because of the breadth of what the Supreme Court has said, or does it not? And regardless of what happens, how it is she decides that case, almost certainly the government, if they lose before her, would take that up to the Court of Appeals. If the defense loses, they would take that up to the Court of Appeals. And the point of all of that is that, once again, the Fisher matter might well delay the further proceedings in front of Judge Chutkan, as matters related to the implications of a Fisher decision coming out of the Supreme Court are bandied about, first at the trial court level. Judge Chutkan could rule in favor or in opposition to what the government is maintaining. Either way, likely that the case would be appealed to the Court of Appeals. They then deliberate on this, and yes, indeed, possible that Fisher via Donald Trump could make its way back to the Supreme Court a second time to determine whether what the Supreme Court says in June on Fisher applies to Donald Trump. That's a lot, I know. That's very wonky. That's a lot of criminal procedure here. That's a lot of procedure in court to consume. The upshot is that the implications of Tuesday's argument are that the pendency of the trial, the scheduling of that trial in front of Tanya Chutkan, thrown more in jeopardy now because the Supreme Court plainly is not going to endorse the government's view about its application and will require more argument before the trial court that also has this on its docket. A lot to consume there. We know, in addition, that Tanya Chutkan, anxious to try this case. She has previously been anxious to do so. Awaiting decisions coming out of the Supreme Court in June. We will continue to watch that in June with respect to both the immunity case, which should in fact be a loss for Donald Trump. The Supreme Court saying, no, there is no such thing as immunity. As to Fisher, now likely saying that the government misused Section 1512, can't be used for this particular purpose, and therefore, at least as to Mr. Fisher and maybe several hundred others, those prosecutions cannot go forward. More litigation coming up then, even when this case goes before Judge Chutkan. We know as well, she is like Judge Merchan in New York. She needs some time to try that case. She needs maybe 6, maybe 8 weeks as well. Jury selection there, presentation of evidence, opening statements, closing arguments, post-judgment arguments and motions perhaps as well. All of that takes time, probably at least 4 to 6 to 8 weeks as well. That's a large chunk of time, and she needs to identify that. She had identified that time early on, way back in March, and she was going to go ahead before all this got taken away from her and from the trial court there while this deliberation before the Supreme Court goes ahead. Increasingly unlikely, as a result of all of this, that this matter, the case involving election interference against Donald Trump, will be tried in this calendar year. Maybe could happen if all sorts of things fall into line, but increasingly unlikely, especially in the wake of this oral argument coming out of the Supreme Court just on Tuesday of this past week, reading those tea leaves and indicating Supreme Court is going to decide in favor of the defense in the Fisher case, and maybe, arguably, depending upon how the Supreme Court writes that case, writes that opinion, will have an impact upon Donald Trump's trial and his case as well. At a minimum, will require more litigation, maybe even appellate litigation as well. I promised at the start that we would talk more about deterrence, and we will do that. I'm going to defer our discussion about white-collar cases involving Sam Bankman-Fried and a Vietnam case until our next week's program. Lots to talk about there, also in the area of specific and general deterrence in the context of major fraud cases. But we observe this coming week, in addition to all the things going on in the trial and the appellate courts of America, we observe something else, which is the 460th birthday of a fellow named William Shakespeare. I believe he was born on April 23rd, 1564, based upon his baptism records, so way back then. Interestingly, we also know that he died on the same date in 1616. William Shakespeare, as you all know well, author of about 154 sonnets, 38 plays, comedies, histories, tragedies, all kinds of things. And so today, as a part of our salute to William Shakespeare, and also our acknowledgement of his frequently inviting us to think about the law, a lot of what William Shakespeare said about the law coming out of his plays. We know in Henry VI, Part 2, maybe the very most famous quote from William Shakespeare. He said, "The first thing we do, let's kill all the lawyers," which is often used today as a criticism of the lawyer. In fact, it's just the opposite. And so if you have friends who invoke that to convey their latest lawyer joke, tell them they've got it wrong. Neither the fact that Shakespeare was unsympathetic to the speaker, there was a fellow named Dick the Butcher in Henry VI, nor that lawyers who represent order and justice has prevented that quote from being used as one of the most popular of all Shakespearean quotes as an attack upon lawyers. In fact, what Shakespeare was saying and what Dick the Butcher wanted to do there in Henry IV, Part 2, was to overthrow government. And he said, in order to do that, what we've got to do is we've got to get rid of the lawyers, because the lawyers are the people who put order together. The lawyers are the people who ensure that the rules are followed. The lawyers are the people, some judges as well, who ensure that there's deterrence along the way. And the only way our successful rebellion will work is if we get rid of the lawyers. So that's the interpretation of that coming out of William Shakespeare. In the end, in Taming of the Shrew, the very first play written by William Shakespeare says this. He says, "Do as adversaries do in law, strive mightily, which we heard a lot about, but eat and drink as friends." Eat and drink as friends. That coming on the Taming of the Shrew. That's Tranio and Grumio, true Grumio. That in the first act, the second scene of Taming of the Shrew from William Shakespeare. We observe his 460th anniversary of his birth this coming Tuesday, and it is in that commission that I invite you back again next Saturday for more of our invitation to, as in the law, strive mightily, but also eat and drink here as friends on Amicus, a Law Review. Thank you for joining me this week. Have a good week, everybody.
You're listening to The Shaw, WAUK, Waukesha's home for the Tom Albaugh Show.
John Mino and Jim Schmidt.
On our next show, we'll find out what's up for the week ahead with meteorologist Brittany Merlot, plus Mike Allen, a Vietnam War vet with a great story.
Mino and the Mayor, weekday mornings 6 till 9.
How was your drive to school?
Let me tell you, I had to get my